Okay, it's 11:30 here on a Tuesday. This is a Tuesday, right? Okay, DJ says it's a Tuesday here. I want to thank you for joining us today for our Golden State Pool Trust MCLE series. This is somewhat of a special program, and especially for those attorneys and professionals that are referring cases to the Golden State Pool Trust. Here, this is something that we really want you to watch. Okay, so this is basically, it's a program on spend downs, and what we're going to do is we're going to talk about a bunch of concepts dealing with spend downs here as options to using a self-settled trust, whether it's a D4A trust or a pool trust or whatever. Now, one thing just to get out of the way here is that for those of you that are watching, if you have questions, and I'm going to expect that there's going to be a fair amount of questions on a lot of these things, if you are on a PC and watching on Vimeo, use the chat, and Amy is watching that chat, and when we get to the end, we'll take those questions. If you are using another device other than a PC on Vimeo, so if you're using your iPhone, your iPad, whatever you're using, in that case, in order to ask a question, what you need to do is email Amy, AMY, at gspt.org. So that's Amy at gspt.org. So part of this, just to get started here, is that that I always look at a self-settled trust as the last option, okay? And there's a lot of cases where maybe there is no other practical option, but but one of the things you always have to remember about a self-settled trust, especially for those, for anyone that gets into it, is that upon the termination of the trust, either upon death or earlier termination, all the Medi-Cal or Medicaid, if you're in another state, that's been used by the benefits recipient has to be paid off during the, if you terminate it. So the problem with it is, let's say you have somebody that gets into this and decides they just really hate the special needs trust, the self-settled trust that they're in, and they'd like to undo it. Well, the problem with that is, in order to undo it, it would be necessary to pay back every dollar of Medi-Cal they've ever used. So as I explained to folks, once you get into these things, the only way, really, the only practical way to get out of it is either to spend your way out or pass away. And I think that's one of the reasons why it's really essential that when you're counseling someone here, that what you're doing is, that you make sure that they've gone through all the different alternatives so they can make an informed decision. Here. So oddly enough, what we're asking you to do is to explore not using the Golden State Pool Trust. And if one of the options doesn't work, then definitely we're here to serve, and we're happy to do that. Getting this out of the way, here, this program's been approved for 1 unit of MCLE credit by the State Bar of California. Each section of this program has a code that the viewer need to record and verify that they participated in the class. So if you don't have the form in front of you, there will be 3 codes within the class. So make sure you write down those codes. And if you do not have the application for MCLE credit, you would get that by emailing Amy at gspt.org. Here. So if you want to receive the credit, you need to download the MCLE credit form and fill out the proper codes. Here in this case, there'll be 3 codes. And to be placed on our mailing list for future programs or to receive the forms or apply to MCLE credit, once again, the thing to do is email Amy at gspt.org. Okay, well, let's get on with our program. This is something that I've always wished that we had the Mission Impossible music, although we're a very small nonprofit, so we probably couldn't afford the royalty rights. But part of this is your mission, should you decide to accept it here, is that you have a client who's 66 years old and competent. Okay, you have no parent or grandparent alive here that can assist you here. Although I will say that we need to update this because with the Fairness Act, and we're going to talk about it here, that if you're under the age of 65, it is very possible here now for you to set up your own trust here. And your client receives SSI, in-home support services, and Medi-Cal. And one of the things we will discuss is there are times when giving up the benefits is something that maybe is an option that you might explore. But in this case, let's assume that your client here is really needs those benefits, and to lose them would be a hardship here, and that losing her benefits would be unthinkable. So she's inherited $60,000. And at this point, she's terrified of losing her benefits. And I know, in our law office, we get these kind of situations all the time. So here's your objective, should you accept this mission here, is to find a way to meet your client's objectives in a way that gets her the highest percentage of value to the client, while that could be administered with competence, okay? And lastly, it's going to have the least amount of risk of loss of benefits. And as I explain to attorneys, like when we do the immersion camps and things like that, especially for us that are in Region 9, and for those of you that don't know it, Region 9 is one of the most difficult Social Security regions around, and they are the most, what's a good term, anal as far as, once again, compliance with rules. And a lot of what we do as attorneys is that we can't eliminate risk. You can do everything absolutely perfectly and still get a denial of benefits because of how screwed up our region is. And that's something we could take up some other time here. And so a lot of it, in some cases, you really have to factor what are the risks involved in doing this, because I will tell you, I have had clients get physically ill. I actually had a client that that we believe a factor of her passing away was the anxiety of losing her public benefits. And unfortunately, this is a very common concern. So this is one of those things that you really have to fit the situation to the client. So let's go through this a bit. Now, prior to December 14th, 1999, one of the things we used to tell folks is that, we wouldn't recommend it, but if you're on SSI, you could actually transfer your assets away to somebody else without a penalty. The very last bill that President Clinton signed before he left office, so thank you very much, Bubba, here, was the Foster Care Independence Act of 1999, which basically provides that if you give it away, if you transfer it for less than fair market value, you're going to be ineligible for SSI for up to 3 years if you've transferred a resource for less than fair market value. Okay? Now, basically what they do is they take the federal benefit rate and divide it by the amount of that you've transferred away, and that'll give you the number of months that you're ineligible, capped at 36 months. Now, there are some cases where maybe transferring a day away would make sense, but you're probably in that case talking about $30,000 worth of SSI if you do transfer it away. As we're going to see, you probably can still keep your Medi-Cal, but with the Foster Care Independence Act of 1999, transferring away really got to the point where it really wasn't a viable alternative. So some of the options to maintaining eligibility are going to include things here when you've that we're going to explore. When you get an inheritance or a personal injury award or something along that line, if you're looking to continue eligibility, is to, one, pay off debt, which we'll talk about in a little bit, because paying off debt is not a transfer for less than fair market value. So if we had a situation where, in this case, we're talking, let's say it's Helen, here has credit card debt that she racked up. And basically, as long as she owes the debt, you really don't have to look at what the underlying what debt was all about. But if she owes it, you can always pay that off without a transfer penalty. You could buy an exempt resource, which we're going to talk about. You could buy a house, you could buy a car, you could buy other things along that line. You could prepay certain services, which we will talk about. You can make certain transfers to certain family members that are allowed by law. You could transfer the funds into a D4A or a D4C trust. So that would be a self-settled individual trust or a pooled trust. Or you could just plain old blow the money. And I've had many situations where it's come up where I've talked to beneficiaries, especially when we're talking, or benefits recipients, when we're talking about a smaller amount. Maybe it's $10 or $15,000. And one possibility is, that I'll ask them, is there ever been something that you've really wanted to do? Go on a trip or do something along that line here. And one possibility is if you could do it, as we're going to talk about, in the same calendar month that you receive the funds, maybe this is the time to go on a trip or do something wild. A lot of folks on SSI, they don't take a lot of vacations and they don't get to go, on their dream trips. And maybe this is the time where maybe the hassle of preserving the benefits is just not worth all the trouble involved. Maybe isn't worth all the hassle. So let's talk a little bit about payment of debt. So here's a practice tip. It's very common that persons involved in a personal injury settlement have had assistance from family members or friends in the form of rent-free loans until the award is received. So it's really common that, while the personal injury settlement is pending, that somebody might, some family member may loan the money to carry them forward while they're waiting to get those funds. Okay? Social Security will always assume that this is a gift unless there is a loan that is going to evidence that there is a loan. Okay, so ideally what you want to do is to be able to document that a loan was made. Not everybody does this, and I believe we'll get into this, and the Social Security Administration does allow it to be a verbal loan. But the thing that you have to look at if you're paying off a loan is that, one, it has to be viable. So for instance, you may have had somebody who loaned the money to the benefits recipient long before the personal injury settlement. Let's say it was $10,000 to go buy something with the expectation that they'll get paid back sometime. But when you're getting $931.72 a month in SSI or less here, it's really not viable. They're going to be able to pay that off. On the other hand, if the loan was made when the lawsuit was begun, then it is viable that it could be paid back. Okay, here. The other thing is it has to be, there has to be an expectation that it's going to be paid back. So what you can't say is, well, pay me back if you feel like it or if it's convenient. That's going to be considered to be a loan, to be a gift. But if in fact what's really going on is what they say is that there is a solid expectation of being paid back when the lawsuit, for instance, is realized, then that's further evidence that it's really a loan and not a gift. So let's go to our first code, which is code number 1 is 8365. That's 8365. Okay, so part of what we're going to talk about here when we start talking about different options here is that we need to start off talking a little bit about the public benefit basics. Okay, so let's just go through some basics here. So first off, for need for benefits, and one of the things you should always do is verify what benefits the beneficiary is on. So for instance, and we get this all the time, we'll have people that'll swear that they're on SSI, and in fact, they're really on Social Security Disability, or they'll swear they're on Medi-Cal, and they're really on Medicare. And so part of what we want to go through, just as we go through this, is a little bit about the basics of these public benefits, so we can make sure we're not making any major mistakes. Okay, so so the needs-based benefits, which is what we're going to really focus on today, are going to be things like SSI, or Supplemental Security Income, Medi-Cal, which is Medicaid in other states, food stamps, legal aid, and utility payments, which once again we're starting to get for SSI recipients in California, big change. HUD or Section 8 or in-home support services. What's common with those programs is you have to show a need based on disability and limited income and resources. Okay. The other types of programs that we'll just touch on basically are the different types of Social Security. So it could be Social Security retirement, it could be Social Security disability, or it could be childhood disability benefits. For folks that are on SSDI and childhood disability benefits, you have to show a need based on disability, but there's no income or resource limit for those programs. With SSDI and childhood disability benefits, 2 years after being qualified as disabled, the benefits recipient will qualify for Medicare, okay, which once again, Medicare doesn't have an income or a resource limitation, okay. And the same thing with special ed. You have to show a need based on disability, but theoretically there's no income or resource limitations there. So the takeaway from this is the first thing you need to do is it's like the old Russian proverb, you need to trust but verify what benefits they're on. Okay? So with that, the important thing is that when we're dealing with a special needs trust, what a special needs trust really is it's a form of a spendthrift trust. And as Social Security says, as long as the trustee has full discretion as to time, purpose, and amounts of all distributions, here you can have any amount of funds in that trust, and they're not counted as a resource because the beneficiary cannot access the funds without going through the trustee. And that's the basic mechanism of how a special needs trust works. If the beneficiary has no discretion over the distributions, the trust is not counted for SSI eligibility. Okay, so as we go through this, let's go through a few basics which will help us with the rest of the program. So for income, there are 3 types of income we're dealing with here, or there's 3 types of special needs trusts we're dealing with. So a third-party trust is a trust where anyone can set it up for the benefits recipient except for the beneficiary themselves. It has to be set up by a third party. The funding can come from anywhere except it can't be something that comes from the beneficiary's own funds. And upon the death of the beneficiary, there are no restrictions on where those funds can be left here, and there's no payback or anything like that. Now we want to contrast that with what we're going to be talking about mostly today, which are the self-settled trust, the D4A trust, and the pooled trust. The D4A trust is only for folks where it's established before the age of 65, which means 64. Okay, so if you have somebody who is 64 years old or younger, That can be set up, you can do just a regular self-settled D4A trust. That can be set up by the beneficiary themselves here, or a parent, grandparent, legal guardian, or a court. And upon the death of the beneficiary, there's a lien for any Medi-Cal. Here the beneficiary is used for medical purposes during their entire lifetime. With a pooled trust, it operates fairly similarly with a little difference. So once again, the source of the funds for a pooled self-settled trust means that the funds here come from the benefits recipient themselves here, but the account can be set up by the beneficiary themselves, a parent or grandparent, legal guardian, or the court, or any of them can sign the joinder agreement here, or the retainer agreement, which is how they enter into the trust. Now, one of the big differences here is that the lien here is for any Medi-Cal that's been used during their lifetime that is not retained by the trust prior to anything going to any remainder beneficiaries. Now, one thing, and we're going to go into this a bit, the Golden State Pooled Trust does not retain funds for two reasons. One is it just kind of sets up a conflict of interest. And the other thing as we go through it is the law says you can't. So I know there are other pooled trusts that do, but we don't. Here, we may later if the law changes, but at the time of this recording in August of 2019, we do not retain funds. Now, as we go through the different options, a couple things to keep in mind. As you might remember, both a pooled trust and a self-settled trust can be set up by the court. Now, if it is set up by the court in California, we're going to be subject to California Rule of Court 7.903, which basically says, with a very few exceptions, here, if you have a trust under supervision, especially a special needs trust, that trust is going to be, it's going to be necessary that there's going to be bond filed for that particular trust or account, that there's going to be accountings which are the first year and then every other year after that, and of course there's an expense that goes with it. And it's going to require court approval for any changes of trustees here, and this is a big one here. Once again, it's going to be subject to those accountings if the amount of funds is greater than $20,000. So that is, so with the $20,000, and this is one of the things that my hope is that we as advocates will be able to change that number, because that has been the same for I don't know how many years here. And you know, it would be nicer if we could set that number a bit higher. The court does have the option of not requiring bond or accountings for an amount higher than that. But generally, most courts, if it's over 20,000, it's going to be subject to court accountings and a bond, and that's going to be a significant cost. And so that may actually weigh in some cases towards maybe doing a spend down or some of the other things we're talking about. So now, as we go through the different options here, we're going to be talking about the POMs, okay? And the POMs are the Program Operation Manual System, which are basically directives to the claims representatives or the field officers here, the folks who work with Social Security, to tell them how to handle certain situations. Okay, the way I describe it is, when you call Social Security, does it seem like they're reading a script? Well, the fact is they're reading a script, and a lot of the times what you want to do is you want to have the script in front of you so you can read this ahead of time. So if there's questions or issues or whatever, you can understand what those issues are likely to be. Okay, so the first POMs we're going to go through, and to find these POMs, one of the easiest ways to do is to do this. If you Google SI space 01120.203, you'll get this section of the POMs. Otherwise, there's a link below where that'll show you how to do it as well. But if you Google that, you will certainly get it. So let's read what it says about a pooled trust. What it says is that a pooled trust is a trust established and administered by an organization. Oftentimes it's called a master trust because it contains assets of many individuals, each with separate accounts established by the individual and each with a separate beneficiary. So what they're saying is, by analogy, it's kind of like a bank that's holding assets of individual account holders. I think of it more like it's like a cross between a special needs trust and a 401k. You don't get your own trust agreement. That's the master trust agreement. But you join by signing a joinder agreement, which basically helps to set up an individual account for each of our beneficiaries. The pooled trust has to be established and maintained by a nonprofit organization. So in this case, the Golden State Pooled Trust is a program of the North Bay Housing Coalition, which is a 501c3 in the Northern Bay Area that focuses on housing needs of persons with developmental disabilities, and also has expanded its mission to include the administration of the Golden State Pooled Trust. Separate accounts are maintained for each beneficiary, but assets are pooled for investment and management purposes. So what happens is here, and for those of you that are beneficiaries, you get a monthly statement which basically tells you what's going on with your account here, and that account, once again, tracks your share of the master trust to the penny here, and the master trust itself is invested. So that's basically, we are in compliance with Social Security and Medicaid law. Accounts are established solely for the benefit of the person with a disability. And this is going to be really important as we start talking about alternatives. And so one of the things you always have to counsel the folks about is, once they join both a pooled trust or a regular self-settled D4A trust, you cannot use the money to make gifts to individuals, including your children. I know one of the toughest times we have is having to explain to our beneficiaries who want to use their funds to buy Christmas gifts for family members. They can't do that because the account has to be solely for the benefit of the disabled individual here. And if you think about it, since there's a lien on the money upon the death of the beneficiary, what they don't want you to do is to be giving it away to avoid that lien. One thing unique about a pooled trust is there are no age limitations. Now, I'm not going to spend a lot of time on this today because I really want to get down to the spend down parts of this here. But there is a lot of discussion going on about whether or not there is a transfer penalty for people on SSI in certain situations. We have yet to have a situation with somebody over the age of 65 who has had a transfer penalty. You do need to make sure you counsel folks that even though this has never happened, it's not impossible that it might happen in the future, and this is something that we are all monitoring here. And groups like the National Academy of Elder Law Attorneys and the Special Needs Alliance have been monitoring this as well, and they are, once again, if we do have a change in policy, they will probably intervene in our favor. So, also, and this is really important, and this will be important for a lot of the spend down things we're going to talk about. If you're using a trust, both a D4A trust or a D4C trust, these are only for individuals who are disabled, okay? So, which means that they're unable to perform substantial gainful activity here based on a disability that's likely to last a year or longer or end in death. Now, if they're getting SSI because they're elderly and poor, then a trust won't work, although all the other alternatives we're going to talk about will work. So one of the things when you're looking at somebody, both who is getting Medi-Cal or they're getting SSI, if we're looking at using a trust, a self-settled trust, you need to make sure they're actually disabled. As an aside, if you're doing this for somebody and you're using a third-party trust, you're an estate planner and maybe somebody's concerned about their grandmother who's on SSI but not disabled, a third party will work. But we can't take grandma's money and put it in a self-settled trust. That will not work. As far as the nonprofit association, it has to be established by the nonprofit association. Here, in purposes of this exemption, it has to be a 501c3 here granted by the IRS, which it has done. So now, once again, I am the trustee, so I am on salary, so but I am under the supervision and the North Bay Housing Coalition here is actively involved in day-to-day operations of the Golden State Pool Trust. As far as the sole benefit, here it must be established for the sole benefit. And once again, if you want to look that up, you would look at SI space 01120.201 F2 for a definition of sole benefit. If the trust provides any benefit to somebody else other than ancillary benefit, then the exception does not apply. In order to qualify for the pooled trust exemption, the trust account must have been established by the individual themselves, or it could be established by a parent, grandparent, legal guardian, or a court. Now, something really important, that if you have a third party establishing the trust account, they have to have the legal authority to act with regard to the assets in the trust. So you might have a parent or grandparent for a child, for instance, that lacks capacity to establish this, that they may be able to establish the account, but they don't have the ability to fund the account. So they would either need a valid power of attorney to give them the ability to do that, or a court order, or something that allows them to transfer the funds into the account. So it's a two-step process. First, you have to be qualified to establish the account, but you also have to have the legal authority to transfer the funds. An attempt to establish a trust account by a third party without legal authority here, or the legal right to act with respect to the assets of the individual, will result in an invalid trust. And Social Security really does check these things. As a requirement, this requirement refers to the individual who physically took action to establish the trust, even though the trust was established with the assets of the SSI claimant or recipient. Now, let's just go through here the reimbursement, or what I like to call the payback. To qualify for a pool trust exemption, the pool trust must contain specific language that provides that to the extent the amounts remaining in the individual's account upon the death of the individual are not retained by the trust, and we'll go through that in a minute. The trust pays the state from such remaining amounts in the account to an amount equal to the total amount of medical assistance paid on behalf of the individual under the state's Medicaid plan. Here, to the extent that the trust does not retain the funds in the account, the trust must be listed as the first payee and have priority over payments of debt and administrative expenses, except as listed in the POMS itself. Okay, so the state shall receive this amount only to the extent that the funds remain in the individual's account and are not retained by the trust. And this is the quirk in this code. So this is something that you might want to look up, Title 22, Section 50489.9, and look this section up just to verify what I'm telling you is true, is that pooled trusts in California are not allowed to retain funds other than to cover management and investment fees associated with that account. Now, I realize there are many trusts that are retaining funds here. We have talked to the state of California, and they said that there is no exemption for any of the pool trusts, including us here. Maybe they'll never have a problem, maybe they will, but we are following the code We may be looking at changing that because, boy, sure, we easily turn back $2 million a year back to Medicaid from our beneficiaries that pass away. And oh, would we love to use those funds for other purposes for our beneficiaries, but the law says we can't. I'll just mention this one other thing here, which is that is one reason that there are some pooled trusts that do retain the funds despite Title 22, and they're able to charge a whole lot less because they're getting their money on the back end. We don't, so we have to stay in the black. So that may be one reason why some trusts are able to charge less than we do. What are the allowable and prohibited expenses? So what you're allowed to pay are taxes due from the trust to the state or federal government because of the beneficiary's death here. Reasonable fees for administration and trust of the trust estate, such as accountings and of the trust to the court, completion of filings of documents, and other required actions associated with termination or wrapping up the trust here. So that's what's allowed. Once again, here are some of the expenses and payments that are examples that are not permitted. So payments of debt owed by third parties. So if there was a debt owed by a third party that was not paid before the person passed away, federal law says we cannot pay that. Funeral expenses are not to be paid under federal law. We'll talk about that a little more in just a minute. And payments to residual beneficiaries are not to be paid until the state is reimbursed. Now, in fact, California has been allowing, in certain cases, the payment of funeral expenses and that sort of thing. But, you know, that's how they're operating today. That could change at any time. So really, one of the things you really should consider when you're working with folks is to get them to pay for a prepaid burial plan and not to wait until after they pass away. In fact, we've been able to pay for funeral expenses in many cases, but that could change at any time. Okay, so this restriction on payments from the trust applies upon the death of the beneficiary. Payments and fees of administration expenses during the life of the beneficiary are allowable as long as they're permitted by the trust document and not affected by the state Medicaid reimbursement requirements. Okay, now we come up to our second code, which is 5920. That's 5920. And once again, if you should be writing down these codes if you're looking to apply for credit. And if you don't have the MCLE credit form, email amy@gsppt.org. So with that, let's go through some case studies. Okay, so here's our first case study. Alexis is 53 years old and was the beneficiary of her mother's life insurance policy with a death benefit of $150,000. Her mother recently died and the death benefit is available to her at any time. She is receiving SSI and Medi-Cal and she wishes to use the funds for a down payment on a home, but she's not ready to move in at this time. Okay, so there's a couple of significant things here. One is that Alexis is 53 years old, and if she's on SSI, she can only be on SSI because she's disabled. Let's say she was 66 years old. You need to dig a little deeper because she might be on SSI because she's elderly and not because she's disabled. So let's go through a couple of fundamentals as we kind of work through what Alexis's options might be. So, for SSI, there are two eligibility tests for SSI once we determine that she's disabled. The first one is an income test that determines how much she can receive. And the second test is a resource test that determines whether or not you're eligible. Now, there are three types of income. So for these purposes, we're only going to be focusing on unearned income in this case. here, but let's go through them. So unearned income is any cash or any payments you get from anywhere you get it. It could be from alimony, pensions, support payments. It could be from interest, dividends, rents, wherever the money, or even from other benefit programs. And so what happens is any money Alexis gets will reduce her benefits for that calendar month, dollar for dollar, after the first $20. So for instance, if what she really got was $100, they wouldn't count the first $20 here, and they would reduce her benefits by $80. In this case, with $150,000, the math is pretty easy. It will wipe out the SSI for that calendar month, okay? And benefits go by calendar month, not 30-day months. If she earned it, she would lose $1 for every $2 she earned after the first $65. On the other hand, if what she's getting is assistance with her food and shelter, whether it's from a trust or another family member or wherever she gets it, here, her benefits would be reduced dollar for dollar for the value of the benefit she received, capped at $277 in the year of 2019. So the month she receives it, it's income. But if she holds it into the next calendar month, it will become a resource. And this is the reason I always teach you that, that you want to look at the income first and resources later, even though it seems like it's backwards. Because our goal is for Alexis is that the month that she has the ability to get her hands on it, it's income here. And in this case, you might remember in the example, it said that she could take the funds at any time. Well, maybe she thinks, I know what I'll do. I just won't claim that money until I'm ready to purchase the house. Well, the problem with it is that Social Security there's a 90% chance that what they're going to do is they're going to say, well, we want to look at the check, and maybe the check says August 2019. And then also, we want to get a verification about when you could have gotten the funds. So it's not when you got them, it's when you could have got the funds, okay? And that doesn't matter whether it's in a life insurance policy or it's in the attorney's trust account. If they have a right to it, it's income that month. But then the following calendar month, it becomes a resource. What's a resource? Anything that can be converted into cash for support is a resource. And if your resources exceed $2,000 on the first day of the calendar month, the beneficiary's SSI will be lost until the resources are reduced below $2,000. So like the very worst time for Alexis to get those funds would be at the end of the month, like the last day of the month, because she would have one day to convert it into an exempt resource or do something with it before it would go into the next month. And if it goes into the next calendar month, which would be the next day, she would lose 2 months of SSI. So some of the exemptions are that she can own a home of any value that she lives in and still remain on SSI. So in this case, what Alexis wants to do is use the money on the down payment of a home. And if she could do that the same calendar month she received it, no problem. But the problem with trying to do it on the same calendar month is that's going to be really difficult, and it's going to really probably cause her to make big mistakes. She can buy any amount of household goods in that home. So for instance, she could buy big screen TV sets, she could buy washers and dryers and all those sort of things. And that might be something, if it's a smaller amount, she'd like to spend the funds on rather than go through the cost or the hassle of going into a self-settled trust. She can own a car of any value, okay, as long as it's used for her benefit. Now, we get this all the time. We have a lot of folks who are quadriplegic or blind or whatever, and they can't drive or they shouldn't here. And in that case, they could still own a vehicle. It just has to be used for their needs, not for somebody else. They can own items related to the disability, so that would be things like wheelchairs, adaptive equipment, and that kind of thing. so she could spend it on that. She can own a life insurance policy with a cash surrender value no greater than $1,500. That's not going to help us. She can own a term insurance policy of any value here, and that's probably not going to help us either. She can own a burial plot of any value, and this is something that, even though it's not a sexy thing to purchase, that's something that might be on the list of things to do. But she can only set aside $1,500 of her own options here for the burial expenses beyond the cost of the plot or the crypt. So what are her options? She could purchase the home in the same calendar month if the money's available. And we've done that. We've had situations where the beneficiary here lined up everything, and especially sometimes with a probate where when the money's coming, because of the whole process of the probate here, or even with the personal injury settlement, because when the attorney gets the funds, they're going to have to clear the liens. So they may be able to say, hey, Alexis, I got this money in August, but I still got to clear the liens, so the money will be available in, let's say, October. So in this case, maybe Alexis can line everything up in October and make the purchase in the same calendar month. The problem with that is it's going to put a real time pressure on Alexis to do this. So it may be practical, it may be not. And it may actually cause her to make a bad decision. But it can be done, okay? She could place her funds into a D4A trust or a pool trust until all the arrangements are made, and distribute that towards the purchase of a residence, which is an exempt resource. So, now what problems might we have if it's in a D4A trust and is established by a court order when it comes to purchasing the home? A lot of courts will want that. In fact, the vast majority of the courts, even though it is allowed for Alexis to own the property, they're going to want the property to be owned by the self-settled trust or the pooled trust. Now, the problem with that is that's going to make the house subject to that Medi-Cal lien upon the death of the individual. Now, what they might try, and I've seen this happen a couple of times, is if the funds could be held like in a living trust, and if you could get the court to hold it in a irrevocable trust, which you would set up under Probate Code 2580 here, which is part of the conservatorship code. If you could get the judge to do that, then it could be held separately and then it would not be subject to the lien. My experience is that very few courts will do this, but I saw a court do this recently here, and which is a very good thing to do. But if it's under court supervision, don't assume that the court is going to okay putting the house in Alexis' name, or even that the house should be purchased. You should ask the court that during the petitioning process for setting up the account. Let's go to our next example. Helen's 42 years old, has been disabled from work injuries, and she's about to receive an inheritance of $32,000 from a probate from her father's estate. Okay, she has no other parent or grandparent alive, and she's on SSI, Medi-Cal, and IHSS. Okay, so she wishes to re-enter the workforce after completing her MBA, and she'd like the proceeds to be used for her education. And of course, we've changed the name for all of these folks, but this is a real case that here we had where, once again, our mythical Helen wanted to go to college. Okay, now a couple things with this. This was written before the ABLE Act. If Helen's injury began before the age of 26, she might be able to put up to $15,000 in an ABLE account and then put the rest, and then she'd have to deal with the rest, and then she could use those funds for education. Here, let's assume that her disability began after the age of 26 here, and so we're going to look at what her options might see. Now, one thing she might look at is whether or not she can prepay her tuition and her other expenses irrevocably here. And so the thing about prepaying expenses, no matter what it is, you can prepay expenses. But remember, what a resource is anything you can get your hands on that you could turn into cash. So if you did that, it would have to be irrevocable, meaning that let's say she went ahead and put $15,000 in an ABLE account if she was qualified to do that, and then she put the other the rest of it and prepaid her tuition and maybe her housing and all that. If there's any possibility that that money could be refunded back to her, that's a resource, and that's going to interfere with her SSI eligibility. Okay, so whenever you prepay something, it has to be irrevocable, and keep in mind, you have to make sure it's not going to be a resource, meaning that they can't get their hands on the funds again. The other possibility is that she could place the funds in a pooled trust and have the trust pay for her school expenses directly. In fact, Ellen is finishing up her MBA at this point, has had a TrueLink card issued to her from her account, and she's paying her school expenses from the TrueLink card here, and therefore we're paying for her expenses directly, and she's not receiving any cash, so she can get her books and she can get her tuition paid as long as the funds go directly from the Golden State Pool Trust for the items that she's purchasing. So once again, this would be options she might want to consider. Let's talk about John. John's 67 years old and is receiving the maximum SSI, Medi-Cal, and in-home support services. He's going to receive a workman's comp award of $34,000. John is receiving, here it says medically needy Medi-Cal, although if he's on SSI, he would be getting his Medi-Cal linked to the SSI here, but however he's getting it doesn't matter that much. And it's unlikely that he's going to need to be in a nursing home so long as he has dependable attendant care. He also receives a total of 150 hours monthly of in-home support services and would like to pay a neighbor for the additional 50 hours of care monthly. Now, for anybody who's considering this, I think about 4 MCLE programs we did was with Rachel Green, with team on issues having to do with employees and that sort of thing, and when is somebody an independent contractor, when they're not. We're not going to really go through that today, but if this is something you were considering, you would definitely want to look at that video. But here in this situation, really what he wants to do, this is very common, that many folks who are getting in-home support services here, I've seldom seen anybody who's gotten an adequate amount of services, and oftentimes they're going to either want to get additional hours or they're going to want to do their best here to maybe enhance the pay of the person that is providing the care. For in-home support services, it's a program that's basically, it's a Medi-Cal program who require attendant care to remain safely in their home. It includes personal care, domestic services, meal preparation, laundry services, and accompaniment to medical appointments and other programs here. It can include, or it does include, paramedical services and protective supervision when necessary. Okay, and so this is a really important program for many of the people we deal with. So since he's on Social Security, we're subject to the SSI rules. The Social Security Administration determines the value of services provided to a transferor or based on the current market value of the services, either monthly or annually, and their frequency and duration under that agreement. So here's the example that they give. In exchange for $9,000 cash, an individual contracts with a yard maintenance services company for 5 years. And the issue is, could you make that payment here and have it not be a transfer for less than fair market value? So basically what the maintenance company charges is $150 a month here, And so for 5 years of maintenance, that would be $9,000 payment. Okay, now if you were going to do this paying for the yard maintenance, you'd have to do it with an irrevocable contract where you're not going to get the money back. Otherwise, it's going to be a resource here. But you could enter into that kind of agreement. So John could enter into agreement with the neighbor and prepay for additional care services, much the way that the example told us how to pay for lawn care, making sure the payment doesn't exceed the actual value of the services. Or John could place the funds in the trust and have the trust pay the workers directly. Now we're going to talk more about the actuarial, making sure that it doesn't exceed the actuarial value. But basically, if we went back to this, let's say that in this example, what did we have? We have John is, we're dealing with $34,000. So let's say, to make the math easy here, what we're going to do is, let's say the value of the services that the neighbor's going to provide here by this contract is going to be for 10 years at $3,400 a year, okay, for $34,000, okay. Here, that you have to make sure, according to the tables we'll see later in the program, that John actuarially is supposed to live, until he's, in this case, 77 years old. I know the tables, and the tables allow him, project that he'll live at least 10 years, and that would meet this requirement. Let me go back to this. Here, let's say John were 80 years old and he's supposed to live actuarially until he's like 85. Well, entering into a 10-year contract is not going to work because the last 5 are going to be a transfer for less than fair market value because the tables say he's only supposed to live until he's 85. We have another example that's going to go through that in a lot more detail. So, John could enter into an agreement here, once again, or he could join the pooled trust, and with the pooled trust, here we would just make the payments, although if it's a neighbor, we would go through RMS team here, which runs about $150 a month here, current cost. And there's going to be the cost of the trust. So part of what John's going to be weighing is the cost of joining the trust, the cost of the administration of the trust, and the cost of RMS, and paying for all the FICA and those things, which he should do. If we kind of space out, those things, if he prepays the funds, then he's not going to have those administrative expenses. But on the other hand, what if he prepays his expenses to the neighbor and the neighbor decides, hey, I'm just not going to provide, I'm not going to fulfill my contract. Well, John's going to be in a real spot trying to get this neighbor to get to work with. So you have to weigh the cost and the hassle against against the benefit, and that's part of, we as counsels of law, that's what we do. Let's go to another option. Okay, so in this case, Beth is 57 years old and has muscular sclerosis, MS. She's currently getting SSI, IHSS, and Medi-Cal. Her only asset is a home worth $900,000, and we see this often times here that folks that are in that have run through just about all of their assets, but what they have left is a home, sometimes with a lot of equity in the home. She can no longer afford to maintain the home and has found a condo for $400,000, which better suit her needs. She would like to sell the house and use the difference for her care without jeopardizing her IHSS or Medi-Cal. So, when you sell your residence, the proceeds of the sale are excluded as a resource if the individual plans to use them to buy another excluded home, which she does, and does so within 3 full calendar months after receiving the funds. And to look this up, and this is a good one to bookmark, you would go to SI01130.110. Okay? So, So part of this is she could buy, if she could swing it in that 3 months, she could take the $400,000 from the sale here and buy the home, buy the condo, and then place the rest in the pooled trust for her care. Or she could put the entire amount in the pooled trust and then purchase the condo, leaving the remainder for her care. Now, once again, she has those 3 months, and in this case, she might want to purchase the home before she puts the remainder in the pooled trust, partially because, once again, with Golden State Pooled Trust, and different pooled trusts work differently, we charge 1.5% of the funds under management. So obviously, paying 1.5% on $500,000 is less than paying 1.5% on $900,000. On the other hand, the problem that we have is that she's only going to have 3 months to be able to make this purchase, which is going to put her under a lot of pressure. So, part of what you've got to be careful about is for her not getting herself in a bind where she has to purchase a house because she's under a time pressure here and making a bad decision. Our next person is Albert. Albert's 25 years old and has been awarded $60,000 from a civil rights suit. Okay. Albert is living with his parents and is able to contribute his share of his household expenses, which would be $1,500 a month here. And he's receiving $657.72. And that number is significant because if I did the math right, the current SSI rate is $931.72. But because there's no way he can pay his fair share of his household expenses of $1,500 when he's getting $931.72. So therefore, he's taking the ISM reduction of $277 a month. So, the Social Security Administration values compensation received in the form of in-kind support and maintenance, basically housing, food and shelter expenses, at its current fair market, current monthly value, either monthly or annually depending on the agreement, multiplied by the length of time which it is provided under this agreement. So part of what we're going to talk about is one of Albert's options would be to enter into an agreement with his parents. And it could be verbal, but it's best if we do this, a written agreement. And with that, he's going to prepay his rent to his parents here for however long that allows. So if the current market rate of rent is $1,500, we would take $1,500 here and divide it by the amount that we have, $60,000, which I think works out to 40 months. Okay, so the value of the compensation is not capped at the 1/3 value here, which is called the presumed maximum value. So let's just go back to what this says. When he enters into this agreement, he would do it at the current value of the housing, not future but current. And as we're going to see, even if the cost of housing goes up, whether or not there is a transfer less than fair market value is calculated based on what happened when you entered into the agreement, not with what happened later. So here's an example in the Palms, and actually as an aside, this is my favorite Palms, and I did a presentation in front of Ken Brown, who was very tickled that, one, I have a favorite Palms, and secondly, what tickled me is this is Ken Brown's favorite Palms as well. So anyway, Ken, thank you for this here. So here's what it says. Mr. Thomas transfers $30,000 cash to his sister based on a written contract that she would provide him with food and shelter for 5 years. The sister values the food and shelter at $500 per month. That's obviously not in the Bay Area. The claims representative, or the field officer as they call him today, develops Mr. Thomas's living arrangements and determines that he has a flat fee arrangement with his sister and he's required to pay $500 a month. The food and shelter for 5 years is worth $30,000, 5 times $6,000 a year. Therefore, Mr. Thomas receives fair market value for the $30,000 he transfers. And here's the key. ISM is not counted because Mr. Thomas prepaid his food and shelter with the $30,000 he transferred. So here's the thing with it. Not only is this an arrangement where he could just give the $30,000 to his sister and you don't have the cost or the administration costs and that kind of thing, but also by prepaying his rent with his own money, he'll get his full SSI rate without a reduction in this example for the 5 years that this contract is in effect. Note, using the same facts in the preceding example, assume that the claims representative is conducting a redetermination 2 years later, and the sister providing the in-kind support and maintenance, the food and shelter, alleges that the value in the food and shelter has increased by $150 a month. Here, since Mr. Thomas entered into the agreement here of $30,000 for 5 years, the claims representative is not to reopen the case here, and so even though the cost of housing went up, the contract is still valid. So in Albert's case, a couple things that comes up is, what if he was 80 years old living with his daughter and is unable to contribute his share of the household expenses, which would be $1,500 here. And he receives approximately $657 a month of SSI. Well, the problem with that is going to be that that when we look at the tables, that these payments are going to be longer than his actuarial life according to the tables, and therefore there would be a transfer for less than fair market value. But we'll go through that in a little bit more detail. So if the SSI recipient creates an agreement that the receiver of the property will provide food and shelter, ISM, for the life of the eligible individual, use the tables, which I have copied, we're going to see in a minute, here in the POMs to determine the total value. Multiply the current market value of the food and shelter being provided by the figure in the years of remaining life column here, which corresponds to the age, which is the next lowest age, of the eligible individual as of the last birthday of the time the resource was transferred. So here's an example that they give here, here in the POMs as a second example. And I know this is involved, but it's pretty important. Valerie Payne transfers non-home real estate property valued at $185,000 to her sister. As compensation, her sister agreed to provide Ms. Payne with room and board in her sister's home for the rest of Ms. Payne's life. ISM development shows that her sister's total household expenses are $1,500 a month. The total household consisted of 3 people, including Mrs. Payne, who was 53 at the time of the transfer. So basically what they're looking at is that the total household expenses is $1,500, but there are 3 people in the house, so they're going to divide it by 3, which means that Mrs. Payne's share is $500 a month. Okay, so that's what it's doing for the calculation, or $6,000 a year. Okay, then you take the $6,000 a year and multiply it by 31.6, the average years of life that are in the table, which we'll see later, which equals $189,660, which is greater than $150,000. In this case, Mrs. Payne received fair market value for the transferred resource, and ISM is not counted because the individual prepaid for her own food and shelter with the value of the home she transferred. And the amount that she transferred was just a hair less than her actuarial life. Let's go through the second example they have in the Palms here to show an example of where this doesn't work. Assume the same facts in this example, except Mrs. Payne is 80 years old at the time of the transfer. In this example, the ISM is still worth $6,000 a year, but at 80 years of age, her life expectancy is 7.16 years. Multiplying 7.16 years times 6,000 comes up with $42,960. In this case, there's uncompensated value of $142,040 here, and therefore the $142,000 and change would be a transfer for less than fair market value, and she would be ineligible for SSI because she, at least for 3 years, because she transferred it for less than fair market value. And that what that's meant to do is to show us how that works for the actuarial value. Now, the data on this table is developed by the Social Security Administration here, and this is the table you're to use. Now, I'm not going to go through this all, but if you do this with a client, once again, part of what you have to do is look at that this actuarial table, and and they go by the table, not by the reality of the situation. For instance, maybe she has Down syndrome, and people with Down syndrome actuarially tend to live a lot less than the regular population. Well, that's not a factor in here. If it says that a 84-year-old is to live 6.59 years, that's the number we use, okay? So it doesn't matter if the family tends to live longer or tend to live less. They go by the table. Now, let's just think about this. In some situations, when you have somebody in a rock-solid living situation and you know they're going to live there as long as they possibly can, and you know they're not going to be taken advantage of, although how could you possibly know that? Then this is a really good way to go. And what you would do is have them enter into a very simple agreement that basically would say, I'm prepaying the rent that we're paying is irrevocable, meaning I'm never going to get it back, because if you could, it's a resource here. And this can work really well. Where can this go bad? What if for some reason the person, the landlord, the sister, whoever you're living with, it just doesn't work out? Or you get into a situation where they get into a terrible fight or something like that. You can imagine you could get into a situation that could be really problematic. So if you're doing this, you really want to make sure that you counsel your clients about these options. You can see that when this does work, what's really cool is there's no administrative costs here, and also you can get the full SSI rate because you're paying the full amount with your funds. For those of you that might be considering this, if you go back to the GSPT website or you go to our YouTube channel here, and for those of you that do ask Amy for the handouts and all that, I'll try to remember to include the links to some of our housing videos. Mary Ebel did a great video that goes through how do you calculate out the household expenses. I believe this is our last example, which is good because we're going to get close to running out on time here. So actually just finishing up with Albert. Albert could put his funds in the pooled special needs trust and pay the monthly sum to his parents, but he's going to incur the ISM. Albert could prepay his rent to his parents, and he could receive the increase to the full SSI for the period of that contract. Okay? So really, the other thing that we did not cover in this is that he could also put some of the money in an ABLE account and use the ABLE account, which you could only put $15,000 in that, and use the ABLE account to pay the ISM, and that would work as well. Now maybe in the case like this, we would do something creative here and put half in the ABLE account and half in the pooled trust. Now think about this. The ABLE account will have more options to Albert, so if we did that, we would want to spend the pooled trust first and then reserve the ABLE account, one, to minimize the fees, And also, if that was the route that we were going rather than prepaying everything here, and we might want to do that and then reserve the ABLE account for him to pay the second part of this. This is our last MCLE code, which is 3286. So here's our last example. Kevin's 54 years old, is going to get an inheritance of $75,000, okay? And he's going to get that directly. He's receiving SSI and Medi-Cal. Because he's under the age of 54, we can assume that he's on it because he's disabled. If he wasn't, then we're going to have to dig further. Kevin would like to give some money to his son, who is also disabled, for his son's future benefits. So if you Google SI 01150.121, you'll find this. Exceptions to transfer into, for transfers into a trust. The period of ineligibility for transferring a resource for less than fair market value does not apply to an individual in the following situations. So it doesn't apply to an individual who transfers a resource into a trust for the sole benefit of the individual's child of any age who is blind or disabled. Okay, this can include what's called a Medicaid trust exception, which is a self-settled trust which is established under D4A or D4C. Now, if this is something that he wanted to do, he'd want to do that before he joined the pooled trust, because the problem with Albert joining the pooled trust is we cannot use the funds for his son because it has to be for his sole benefit. So for a period of ineligibility here to transfer to a disabled or blind individual under the age of 65, the period of ineligibility does not apply to an individual who transfers the sources for the sole benefit of an individual, including himself or herself, who is under the age of 65 here. And once again, that includes a D4A or D4C trust. The period of ineligibility for a non-home resource at less than fair market value also doesn't apply to a transfer to the transferor's spouse, okay, including a separated spouse, or another person for the sole benefit of the transfer spouse, or a transfer to a child of any age who is blind or disabled. So Kevin could put his funds in the pooled trust, but the funds would need to be for his sole benefit. Instead, he could transfer some or all of the funds into a trust for his son. Anyway, those are our examples today, and just as examples of how to work through this. And part of what we're asking folks to do is that, before you counsel somebody, not only just into the Golden State Pooled Trust, but even when you look at a self-settled trust, consider the options. And there may be times when the options make more sense. One of the things you really want to make sure that you do this, just to reiterate, is once you're in the trust, really, if for some reason there was a reason why we no longer needed the trust and wanted to unwind it, we would have to pay back any Medi-Cal or Medicaid that person received during their entire lifetime. And in most cases, that is a huge number. Okay, with that, Amy, do we have any questions at this point?
I just have one question that
Yes.
I got from a viewer. It's had to be with regard to Helen, but I think you might have addressed the answer in your example about Thomas.
Yeah.
But the question was, why bother putting $15,000 in an ABLE account if the inheritance was $50,000?
Well, and the reason that you might, just to answer the question, is at least that would be $15,000 that he would have control over, and you could use that for housing. Part of this is the other part you might look at is that if you are going to join the pooled trust with the rest of the funds, at least that'll shorten the amount of time that we would have the funds, which would shorten the amount of fees. I mean, there's many factors you're looking at. I think one of the values of the pooled trust is that you're going to have the oversight of staff that are knowledgeable, and it may be the safer way to go. But on the other hand, especially with these smaller amounts of funds, the goal is to really try to stretch out the funds as much as possible. And I will say, it goes back to what I said in the beginning, it's not just trying to get the best benefits possible, but it's also, if you get into something elaborate, the more elaborate situation you get into, the more chance that something's going to go wrong. So I'll give you an example. We used to do very complex spend downs. So we do something where we're spending money on improving the house. We're spending money on purchasing a car. We're spending money to, prepay this, and we're buying wheelchairs and all that. The more things that you have that you're doing with the spend down, the more things you're going to have that Social Security is going to be reviewing, and the more chances that they're going to find fault with something, right? And so when you get into these elaborate spend downs, even when you do everything right, there's a really good chance that Social Security will take an exception to something. And the fact is, in a lot of these situations, even when you win in those appeals, you kind of lose because of the loss of time and the expense involved in it. So really, part of it also is to try to keep it simple when you're doing spend downs. Most of the things we talked about were simple. The other thing is, if you're doing something based on one of these examples, especially when you're dealing with SSI, it's best to come as close as you can with the example. So with the example where you're prepaying rent through a contract, then you'd want to include not only a copy of the contract, and we make up one in the office, which is probably the silliest looking contract you ever saw. It's one page, but it basically says, hey, I'm entering into this agreement, it's irrevocable, this is covering my food and shelter for the next few years, and it's not a very elaborate thing. We include that and a copy of the POMs and highlight the example. You want to make sure what you do comes as close to the example in the POMs as you can, so we can make it as simple as we can on the eligibility of workers. Okay, so that is the question we have here. So for those of you, once again, watching, a couple of things going on. If you're new to us and you would like to get notices of future programs, as well as get the information that you need to get your MCLE credit, whether you're an attorney or a fiduciary, you would email amy@gspt.org. Also, keep an eye out because we have new programs coming up, and we're also very involved with the Life Passage Planning Project, and we'll be doing programs across the state about that. And we're very excited about this, not just for ourselves, but for other fiduciaries, and how this could increase the availability of affordable assistance for folks with disabilities in the community, to help them with things like keep their receipts, go to the doctors, and go to Social Security, something to be covered later. With that, I want to thank you so much for watching today, and so if you're interested in further future programs, please email amy@gspt. Thank you very much, and happy advocating.